Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. Starting with the update from the Supreme Court, which today issued notice on a plea by former Andhra Pradesh Chief Minister N. Chandrababu Naidu for anticipatory bail in the FiberNet scam case. Naidu, who is Telugu Desam Party President and former Chief Minister of Andhra Pradesh, has been accused of playing a key role in the Andhra Pradesh FiberNet scam that happened during the TDP term in the state. The Andhra Pradesh CID accused him of exerting pressure on officials to favor a certain company that was awarded the FiberNet contract, despite its alleged lack of necessary qualifications. This case was actually registered back in 2021 and Naidu was recently implicated. Naidu has called this a politically motivated decision. Earlier this week, his plea for anticipatory bail in this case was dismissed by the AP High Court. He then approached the Supreme Court. A bench of Justices Aniruddha Bose and Bela M. Trivedi today issued notice in his plea, pointing out that a warrant had been issued to produce Naidu for Monday, that is 16th October. Senior advocate Siddharth Luthra, appearing for Naidu, voiced his concern regarding an imminent arrest. At the court's insistence, senior advocate Mukul Rohtagi, on behalf of State of Andhra Pradesh, informed the court that Naidu would not be arrested till Wednesday. You already know that the Supreme Court is also currently hearing a special leave petition against an order of Andhra Pradesh High Court, which dismissed Naidu's plea for quashing the FIR in skill development scam case. The Supreme Court today criticized the Speaker of Maharashtra Legislative Assembly for laying down a long schedule for hearing the disqualification petitions filed by the Uddhav Thackeray and Eknath Shinde factions of Shiv Sena against each other. The bench of CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra today was hearing a writ petition filed by Sunil Prabhu, who is member of Uddhav Thackeray faction, seeking expeditious decision by the Speaker. In September, the court had expressed dissatisfaction with him for keeping the disqualification petitions pending since July 2022 and had asked him to lay down a schedule for hearing. Today, senior advocates Kapil Sibal and Dr. Abhishek Manu Singhvi, appearing for the Uddhav group, informed the court that the Speaker has now framed a hearing schedule for 1 year, laying down an elaborate timeline for cross-examination and recording of evidence. Sibal wondered whether the procedure was a civil suit. He stated that the proceedings under the 10th schedule are supposed to be summary in nature. The CJI conveyed displeasure of the bench regarding the Speaker's conduct to Solicitor General Tushar Mehta. When the Solicitor General asked that as the Speaker was exercising powers under the 10th schedule as a tribunal, whether Supreme Court could interfere with the day-to-day functioning of the tribunal or not, the CJI asserted that as a tribunal, the Speaker was amenable to Supreme Court's jurisdiction. The court also said that decision had to be taken well before the next elections and delay could not go on merrily to render the whole process infructuous. The bench adjourned the hearing till next Thursday and orally observed that the Speaker must take a decision within 2 months. Did you know that various organizations like the All India Ophthalmological Society conduct live surgery broadcasts, where live demonstration of medical surgeries to trainee doctors, professionals, and medical conferences is conducted? The audience could include hundreds of persons who actively participate by asking questions to the surgeon while the procedure is ongoing. Well, a plea has been filed in the Supreme Court challenging such broadcasts. The plea states that such demonstrations pose significant challenges to informed consent, that patients from lower economic strata agree for the same as they are provided surgery waivers for live surgeries and do not realize that the surgeon's attention may be divided when they know that they are being broadcasted live, potentially putting patients at risk. The police cites a specific case from 2015 where a live surgery broadcast conducted by a leading hospital in the national capital of Delhi resulted in the death of the patient. The petitioners have sought directions for the National Medical Commission to appoint a committee that will regularly monitor live surgery broadcasts and establish comprehensive guidelines. Senior advocate Gopal Sankar Narayan, appearing for the petitioners today, raised a series of concerns regarding the same. While at the outset, the CJI did remark that the live broadcasting was done for educational purposes, upon hearing the arguments, he agreed to issue notice in the matter. Thus, the Supreme Court bench comprising the CJI, Justice J.B. Pardewala and Justice Manoj Mishra issued a notice returnable in 3 weeks. In another update, the Delhi High Court today dismissed the pleas filed by NewsClick founder Prabir Purkayasth and Human Resources head Amit Chakrabarti challenging the trial court order which remanded them to 7 days of police custody in the UAPA case registered following allegations of the portal receiving money for pro-China propaganda. The duo is presently under judicial custody since 10th October, which is expiring on 20th October. Appearing for Purkayasth, senior advocate Kapil Sibal had submitted that he was not supplied with the grounds of arrest. He also claimed that not a penny was received by them from China. On the other hand, appearing for the Delhi Police, Solicitor General Tushar Mehta submitted that the arrested persons were in fact informed about the grounds of arrest. However, he said that it is an admitted fact that the grounds of arrest were not supplied to the duo. Justice Tushar Rao Gadela upheld their 7 days of police remand. While dismissing Purkayasth's petition, Justice Gadela said that the grounds of arrest were indeed conveyed to them, that there was no procedural infirmity or violation of any provisions under UAPA or the Constitution. And now an update on the Maratha Quota verdict. If you remember, in May 2021, a constitution bench of the Supreme Court had struck down the Maharashtra legislation providing reservation to Maratha community in the socially and economically backward classes. The bench struck down Maharashtra SEBC Act of 2018 to the extent it held Marathas as socially and economically backward class, saying it violated the principles of equality, as no exceptional circumstances were shown to provide quota for Marathas by breaching the 50% ceiling limit. The bench had also held that states had no power to identify socially and economically backward classes after the 102nd Amendment to the Constitution. Then in July 2021, the 5-judge bench dismissed the review petitions filed against this judgment. The central government had also filed a review petition against the judgment to the extent where it held that state had no power to identify SEBCs. But the bench had dismissed centre's review petition also. Now, a curative petition has been filed against the judgment. This morning, senior advocate Maninder Singh, appearing for the state of Maharashtra, mentioned the matter before the CJI for urgent listing. The Supreme Court said that it will list the petition in due course. The next update is regarding the ongoing petition for medical termination of pregnancy of a married woman who is 26 weeks pregnant. Today again, the matter was heard by a bench of CJI D.Y. Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra. The court today doubted the authenticity of the postpartum psychosis prescription provided by the petitioner to the court. Additional Solicitor General Aishwarya Bhati, appearing for Union of India and opposing the medical termination of pregnancy in this case, today said that India, with the Medical Termination of Pregnancy Act, was a pro-choice legislation, but the rights of an unborn child also had to be balanced. On the other hand, Advocate Amit Mishra, representing the petitioner, emphasized the severity of her mental health condition, indicating a history of attempted suicide and self-harm, making a compelling case for the termination of her pregnancy. Further, the bench passed an order directing the AIIMS Medical Board to examine whether the fetus was suffering from any substantial abnormality and whether the medications that she is taking would risk continuance of full-term pregnancy. The matter will now be taken up on Monday. Stay tuned with us. As you know that the Darwinian theory of evolution is a scientific explanation for how species of living organisms change over time. Also known as survival of the fittest, the theory has been supported by extensive scientific evidence, is the foundation of modern biology, and provides a natural explanation for the diversity of life on Earth. Interestingly, a PIL was filed in the Supreme Court challenging Darwin's theory and Einstein's equation, that is E is equal to mc square. The petitioner today told the bench, comprising Justices Sanjay Kishan Kaul and Sudhanshu Dholia, that whatever he had been taught in school and college was wrong and that 20 million people had died accepting Darwin's theory. But the bench said that the court had nothing to do with his belief and asked him to show how his fundamental rights had been violated. Accordingly, the court dismissed the petition. And lastly, a Delhi court today remanded Aam Aadmi Party MP Sanjay Singh to 14 days of judicial custody in the money laundering case connected to the Delhi liquor policy. As you already know, he was arrested on 4th October by the Enforcement Directorate. This was after searches were conducted at his residence in the national capital. Singh was today produced before Special Judge M.K. Nagpal of Rouse Avenue Courts after expiry of his 3 days of ED custody. And he has been sent to judicial custody now. Meanwhile, he also approached the Delhi High Court challenging his arrest and ED custody. Urgent listing of his petition was allowed for today, but the petition has not been listed yet. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.